Well, tonight we're checking in on Oregon's public defense crisis. Back in April, Governor Tina Kotek fired the head of the Oregon Public Defense Commission. That's the agency in charge of the state's contracts with public defense firms. Kotek then installed a new director, Ken Sanchagrin, there he is, with the clear expectation he would come up with a plan to reduce and eventually eliminate Oregon's backlog of unrepresented criminal defendants. Okay, as of today, there are still more than 3,000 criminal defendants without an attorney in Oregon, and most of them are not in custody. It's worth noting, though, the number of people without representation is trending in the right direction, because back in the spring, it topped 4,000. Sanchagrin delivered his 12-month plan to the governor in June. Much of it depended on a new contract his office was working on for public defense firms to sign. That new contract began in October 1st. But one public defense firm in Marion County has refused to sign it, even going a step further and suing the Oregon Public Defense Commission, or OPDC. They argue the new contract is unconstitutional and that it will require their attorneys to take more cases than they can ethically handle. Shannon Wilson is the executive director of Public Defender of Marion County. They said the contract they were handed by the OPDC would force them to cut positions right off the bat.
In that contract that was proposed, they had already removed 5 positions from that contract. Yeah, so they already their intention was to remove public defenders from Marion County.
At a time where there still are unrepresented people and not enough public defenders to represent those people.
Okay, that last person you just heard from is Josh Krumholtz, an attorney representing Wilson in their battle with the state. Now, the job cuts are certainly a problem for Wilson, but they aren't the problem at the heart of the lawsuit. That has to do with the number of cases each public defender is expected to take. Since 2021, Oregon has used something called the Maximum Attorney Caseload Standard, or MAC. It's exactly what it sounds like, a framework for the maximum number of cases a public defender can ethically take on, with cases weighted by type. Criminal attorneys we've talked to on both sides of the courtroom are ambivalent about the MAC, with most telling us it's imperfect at best. But under this new contract, Wilson says the state has subtly changed what the MAC means. It's still the standard, but now it's not a ceiling for the number of cases public defenders take on. It's become the floor.
So it's a quota system. It's a mandated caseload that's imposed on every lawyer. And in this quota system, the contracts weren't necessarily based in anything that was like, it wasn't based in the realities of the work. So it imagines, one problem is that it imagines that an attorney that starts a contract has no clients, right, doesn't already have a full caseload, and then would be required to take on a certain number of additional cases within that year. And so it just turned the contract into just a sheer number standard. Essentially, each year, a public defender with an already full caseload is required to pick up an additional equivalent of 300 misdemeanors mandated.
Now, as the director of a public defender office, Wilson says the contract takes away their ability to manage workloads among attorneys. Right now, everyone is supposed to take a MAC load of cases each year, regardless of what's going on with their cases or their personal lives.
A good example of what public defenders are forced to do under this contract is, on average, they would only have allotted to them 5.25 hours to handle a misdemeanor case. They need to have the ability to investigate the claims, interview witnesses, meet their client and interview their client, look at discovery, look at body cams. The 5 hours runs out in the blink of an eye. So the consequence is that the public defenders are forced to take whatever deal is on the table and just get the best deal that they can get without even knowing whether it's the right deal for that client, because they're just denied the opportunity to do their job.
They're arguing the new contract from OPDC violates the Oregon Constitution and state law by forcing lawyers to act unethically.
We're asking the court to render that ruling, that a contract that requires this number of cases that's set at the MAC level is unenforceable as a matter of law because it violates the Constitution and because it requires lawyers to handle more cases than they're capable of handling, and rendering it a violation of our own ethical rules.
Okay, so what does all this mean and why does it matter? Well, the goal of this lawsuit is not just about getting a new contract from OPDC. They want a ruling to force the state to use a new caseload standard, replacing the MAC entirely, basically upending how the state plans to eliminate the unrepresented defendant backlog, throwing a whole new wrench into this crisis. And it's not outside the realm of possibility. Under the previous director, the OPDC actually already adopted a caseload standard that public defenders like Wilson have been pushing for. But despite adopting it, the state is not using it. The Washington State Supreme Court has been leading an effort to create a more ethical caseload standard for public defenders. Their new model takes effect in January, although it's somewhat of a soft launch because it won't be fully in effect for another decade. And Oregon originally moved to the MAC standard, following in Washington's footsteps. But as our northern neighbor leaves the MAC behind, Wilson and Krumholtz hope their lawsuit could help Oregon do the same.
It is the state Supreme Court that ultimately has the responsibility of making sure that justice is applied equally and fairly. It is the state Supreme Court that is responsible for making sure that the rules of ethics are being followed. The legislature doesn't decide either one of those things. So yes, it's our belief that the legal community as a whole, and the Supreme Court in particular, has a responsibility of determining what constitutes constitutional and ethical behavior in their courts.
We wanted to talk to the Oregon Public Defense Commission about all this, but they said they can't comment on pending litigation. Right now, Public Defender of Marion County is still working on its cases from the previous contract, but they are not getting assigned new ones. They're trying to work out some kind of agreement with OPDC in the meantime. A first hearing on the lawsuit is scheduled for Friday in Marion County Circuit Court, and we will keep you posted. So talk to us. What do you think about this latest twist in the public defense crisis? We know it's a little dense at times, but obviously critically important to our state's justice system. Email us the story at kgw.com or call and leave us a voicemail 503-226-5090.